appeal in the matter of JTI Acquisitions Company 2011 Limited and the Commissioners for His Majesty's Revenue and Customs.
Yes, Ms. Shaw.
Good morning. I appear on behalf of the appellant, JTI Acquisition Company, together with my learned friend, Mr. Harry Winter. My learned friends, Ms. Elizabeth Wilson KC and Ms. Rebecca Sheldon, appear on behalf of the respondents, HMRC. Before I get going, can I just raise two matters with you? The first is that we have transcribers. I'm not sure if you're aware of that, but I was going to propose that we take a short break at about 11:45, if that's
No, I'm
convenient.
sorry, in this court we don't have breaks for transcribers. If necessary, they can go to the recording.
Fine, okay, well, I'll push straight on through. The second point I wanted to raise was you should have received an additional authority to slot into the back of Volume 2 of the Authorities Bundle, which is the most recent decision in Quick Fit, and I just wanted to check that you have that.
Yes.
Super.
And I can tell you that we have read both decisions below. We have read the skeleton argument. It will not surprise you to learn that we have also read BlackRock, which I
Yes.
think you will need to confront quite early on.
I will. You're anticipating correctly. So this is the third of three appeals to this court concerning the unallowable purpose rule contained in sections 441 and 442 of the CTA 2009, which forms part of the Loan Relationships Code governing the treatment of lending transactions for corporation tax purposes. Now, under that code, interest and other expenses incurred by a borrower company are deductible, and any deficit or loss resulting from an excess of debits over credits can be utilised in the normal way, including by way of surrender to other group companies for utilisation against their UK profits. The loan with which this appeal is concerned is a $550 million loan note issued by the appellant, which was a UK SPV within the Joy Global Group. And the Joy Global Group is a multinational group headquartered in the United States. That loan was used to fund the acquisition of Letourneau Technologies, another multinational group headquartered in the United States. Now, none of the key facts are in dispute. In particular, there were bona fide commercial reasons for acquiring Letourneau Technologies. There was a funding shortfall within the group to meet the $1.1 billion purchase price. The loan was on arm's length commercial terms. The loan was in fact used to acquire Letourneau Technologies. Nor is it in dispute that the acquisition structure was formulated with tax considerations in mind, and that it was understood and intended that the acquisition of Letourneau Technologies by the appellant would provide a tax advantage in the form of loan relationship debits, which would then be available for surrender by way of group relief. So the issue which arises in this case is whether the interest debits fall foul of the unallowable purpose rule, because the reason why the appellant, as opposed to any other group entity, was chosen as the acquisition vehicle was to obtain that tax advantage. And
I think it wasn't just chosen, it was created.
it was created, yes, but that is the rationale for its presence in the acquisition structure. And in our submission, quite shortly, the debits do not fall foul of the unallowable purpose rule, because what the rule is concerned with is the purposes for which the company was a party to the loan relationship, and not the reasons why the company, as opposed to any other group entity, was chosen to effect the acquisition. So that's the basis of our first ground of appeal, and that, we say, is the essential error that appears in the decisions of the tribunals below. In short, we say they focused on the wrong question, the reasons why the appellant, as opposed to any other group entity, was chosen to acquire LTT, instead of the rather more precise question posed by the statute, which is the purposes for which the appellant was party to the loan relationship. And as to that question, on the facts as found, we say the plain and obvious answer is to acquire Latorno Technologies. The purpose was not to obtain a tax advantage. That was simply an intended and inevitable consequence of the loan relationship. Or, if that was a purpose, we say that in the context of a $1.1 billion commercial acquisition, it wasn't a main purpose. And so that is the basis of our second ground of appeal, namely that having asked the wrong question, the tribunals below failed somewhat inevitably to have regard to the material facts of the case. And then our third ground of appeal is that even if the appellant did have a main tax purpose for being party to the loan relationship, none of the debits are properly attributable to that purpose in circumstances where the whole of the borrowing was required and used to fund the acquisition of LTT. So can we start, please, with the legislation, which is behind tab 1 of the authorities bundle. Starting with section 441. So this section applies if in any accounting period a loan relationship of a company has an unallowable purpose, and in that event, subsection 3 provides that the company may not bring into account for that period so much of any debit in respect of that relationship as on a just and reasonable apportionment is attributable to the unallowable purpose. And then subsection 6 directs you to section 442 for the meaning of has an unallowable purpose and the unallowable purpose. And then over the page, we have section 442, which provides that a loan relationship of a company has an unallowable purpose if the purposes for which the company is a party to the loan relationship include a purpose, the unallowable purpose, which is not amongst the business or other commercial purposes of the company. And then subsection 3 provides that subsection 4 applies if a tax avoidance purpose is one of the purposes for which a company is a party to a loan relationship at any time. And subsection 4 provides for the purposes of subsection 1, the tax avoidance purpose is only regarded as a business or other commercial purpose of the company if it is not the main or one of the main purposes for which the company is a party to the loan relationship. And then subsection 5 provides that the references in subsections 3 and 4 to a tax avoidance purpose are references to any purpose which consists of securing a tax advantage for the company or any other person. And then 476 is the definitions provision. And you'll see that it defines tax advantage by reference to section 1139 of the CTA 2010, which is behind tab 2. And you can see tax advantage there in subsection 2 means, amongst other things, a relief from tax. So it's common ground that obtaining a loan relationship debit for surrender by way of group relief is a tax advantage for the claimant companies.
And I think it's also common ground that tax advantage means a UK tax advantage.
Correct, yes, thank you. So drawing those strands together, if the main purpose or one of the main purposes for which the appellant was a party to the loan relationship was to obtain an interest debit for surrender by way of group relief, then the debit is disallowed to the extent that it is attributable to that purpose. And the relevant principles in the application of that test are helpfully summarised in the recent decision in BlackRock, which I want to go straight to, and that is in volume 2 of the authorities at tab 22, please. This is the Upper Tribunal decision, and I want to start with this because there's a helpful diagram at the back of the Upper Tribunal's decision which shows in diagrammatic form the arrangements in issue in BlackRock.
So you want us to go to Appendix 1?
Please, yes, page 5, 6, 7. So the first point which immediately jumps out when looking at this diagram is that the loan in issue, which is the loan from LLC 4 to LLC 5, is the only debt in that structure. Every other link in the ownership chain involved contributions of cash and equity. And what that demonstrates is that the group didn't need to borrow in order to fund the acquisition of the target. The second point to note is that LLC 5 was not the acquiring entity. The acquiring entity was LLC 6. And the third point to note is that both LLC 5 and LLC 6 are funded by LLC 4. So what LLC 5 acquired was preference shares in LLC 6. And whilst those shares gave LLC 5 a right to the majority of the dividends declared by LLC 6, those shares did not give LLC 5 control of LLC 6. So control of LLC 6 was vested in the ordinary shares, which were held by LLC 4. So it is apparent from this diagram that LLC 5 had no commercial rationale. Its presence in the acquisition structure didn't serve any commercial purpose in acquiring the target. In essence, LLC 5 was a commercially redundant conduit inserted into the acquisition structure solely to introduce unnecessary debt in order to generate loan relationship debits.
But didn't the FTT find and the Court of Appeal agree that there was a commercial purpose?
There was a commercial purpose, but it was a byproduct. I'll show you this in a moment. It was a byproduct of the tax purpose. It was to give LLC 5 an income stream so that it wasn't thinly capitalised. So if we can move to the Court of Appeal's judgment, which is behind tab 26. And I'd like to pick it up at paragraph 105 on page 654, please. And we say that 9 principles emerge from this judgment in BlackRock. Firstly, as the Court of Appeal explained in Travel Document Service, what matters is the company's subjective purposes in being party to the loan relationship in question. So in the present case, that means the appellant's subjective purposes in being party to the $550 million loan. Over the page, in paragraph 107, the second principle is that the purposes for which a company is a party to a loan relationship may or may not be the same as, for example, the purposes for which the company exists, or the purposes of a wider scheme or arrangements of which the loan relationship forms part, and which may, for example, encompass the purposes of other actors. So the question is not why does the appellant exist, or why was the appellant selected as the acquiring entity, or what were the purposes of the wider arrangements of which
Is
the
that
loan
what Lady
relationship
Justice
forms
Falk is
part.
saying? Is that what Lady Justice Falk is saying? She doesn't say it may not. She says it may or may not.
Well, may or may, I would respectfully interpret that as saying they are different questions. They may or may not result in the same answer, but if you like that is happenstance, she's clearly denoting that they are different questions. If they weren't different questions, she wouldn't bother to point out the distinction. I would respectfully say what she is saying in 107 is that the relevant question is what were the appellant's purposes in being party to the loan relationship? Now, in a case like BlackRock, the answer to those different questions was in fact the same. In BlackRock, the purpose for which the company existed and the purpose for which it was a party to the loan relationship were the same because, as she goes on to explain, the company's sole raison d'etre was to enter into the loan relationship to generate interest debits. But what she's saying in 107 is that the relevant question is still what are the purposes for which the company is a party to the loan relationship, and not what are the purposes for which the company exists. Our third principle is in paragraph 108. A company can only act through human agents, and therefore in identifying the subjective purposes of the company, it's necessary to consider the subjective purposes of the relevant decision makers. And ordinarily this will be the company's board of directors unless the board has been bypassed or was acting on instruction. So what you're looking for are the subjective purposes of the company's decision makers in resolving that the company should become a party to the loan relationship. Then over the page, at 114, object or purpose must be distinguished from effect.
Sorry, 114?
114, yeah.
Oh yes, I see, yeah.
So object or purpose, as the language is in our instance, must be distinguished from effect. And you will recall from our skeleton argument that we set out a passage from an article that was written by Lord Millet, where he explains purpose is the aim, the object, the end in view, what the company is trying to achieve by being party to the loan relationship. Effect is the result achieved or the actual consequences. So we say it's not enough that a loan relationship results in an interest debit. That will always be the case when a company pays interest on a loan. The question is whether that was what the company was trying to achieve by entering into the loan relationship. Principle 5 is in paragraph 116. Object is not inevitably limited to conscious motives. And this is a point which emerges from the case law concerning the wholly and exclusively for the purposes of a trade test. And one of the cases is Malalieu and Drummond, which concerned expenditure incurred on sober courtroom garb. And the point in Malalieu and Drummond was that the purpose of warmth and decency, which Ms. Malalieu's courtroom attire served, was an undeniable purpose, even though that was not what was in her mind at the time that she incurred the expenditure. Over the page, paragraph 120, our sixth principle is that motive is not the same as purpose. And again, Lord Millett explains, motive is the reason why the company is trying to achieve its aim. Also in paragraph 120, principle 7, some results or consequences are so inevitably and inextricably involved that they must be taken to be a purpose. So that was the case in Malalieu and Drummond, and also similarly in the McKinley and Arthur Young decision, which concerned expenditure on home furnishings for partners relocating to another partnership office. And in those instances, the expenditure could not but be said to be for private purposes as well as business purposes, since that was the inevitable and inextricable consequence of the expenditure. However, and this is an important qualification to principle number 7, principle number 7, this is our 8th principle, and it's set out in paragraph 124b. Effects or consequences, even if inevitable and inextricable, are not necessarily the same as objects or purposes. And this is illustrated by Lord Brightman's example in Malalieu and Drummond, which is set out in paragraph 113 of Bill's decision, of the doctor attending on a patient friend in the south of France. That inevitably resulted in the doctor getting to spend a week on the French Riviera, but that did not necessarily mean that a purpose of the trip was to enjoy a week's holiday on the Riviera. And similarly, in Vodafone and Shaw, which is the third of these wholly and exclusively for the purposes of trade cases mentioned in BlackRock, the fact that the expenditure, in that case, it was expenditure in order to terminate a contractual obligation. The fact that that expenditure inevitably was of benefit to the group did not mean that obtaining that group benefit was a purpose of the expenditure. As Lord Justice Millett, as he was, explained, the expenditure was incurred solely for the purposes of the taxpayer company's trade, because the contractual liability was that of the taxpayer company alone and not of any other group company, even though economically the burden of the contract was borne by other members of the group. And then finally, the 9th principle is in paragraph 124 little f, and it's that the company's object or purpose is not determined simply by asking the decision maker. And we say that is a reference to Lord Justice Millett's observation in Vodafone, that once the purposes have been ascertained, their characterisation as, in that case, trading or private purposes, in this case it would be as commercial or tax purposes, is a question for the tribunal. It's a conclusion reached based on the primary facts. It's not a question of asking the decision maker of the company, was this a trading purpose or a tax
Although you've
purpose?
identified 9 principles, aren't they really all summarised in 124? Apart from the human and agent point, which really runs under A, perhaps, it's all there, isn't it? And what Lady Justice Fox said in 124. Do we need to go Isn't that enough?
I don't have to go back over them, possibly.
Right.
It's I've broken it down a bit more, but if you feel that 124 encapsulates all of those, then I'm not going to die in a ditch about my 9 principles. So the judgment then goes on to highlight various errors in the approach below, and at paragraph 150, the court grapples here with the interplay between principles 7 and 8 in the context of the unallowable purpose rule, and explains in that paragraph that tax relief for interest and other expenses of raising debt is obviously a valuable relief, and one which it is unrealistic to suppose will not form part of ordinary decision-making processes about methods of funding a company. And it goes on to say, indeed, it may well be wrong for directors to ignore that consideration in deciding what is in the best interests of the company concerned. And then it concludes, it cannot have been Parliament's intention that the inevitable consequence of taking out a loan should engage the unallowable purpose rules, subject only to consideration of whether the value of the tax relief is sufficient to make it a main purpose. Something more is needed. So we say simply understanding and intending that an interest debit will arise as an inevitable consequence of a loan relationship does not mean that obtaining that debit is a purpose for which the taxpayer is a party to the loan relationship. Then in paragraph 153, the court criticises the Upper Tribunal for referring to the purposes of LLC 5's existence and inclusion in the transaction. And we make a similar criticism of the tribunals in this case. We say the essential error in the decisions below is that they focus on the reasons why the appellant, as opposed to any other group entity, was chosen to acquire LTT, instead of on the purposes for which the appellant was a party to the loan relationship. Then in paragraph 154, the Court of Appeal rejects the suggestion that the subjective intentions of the board were circumscribed simply because the board were instructed to leave tax considerations out of account, and instead explains that it was entirely proper for LLC 5 to be told to leave tax considerations out of account when it would not itself have benefited from the tax advantage. So in BlackRock, again, the intention was to surrender the debits to other UK group companies for offset against their profits. And we highlight that paragraph because a similar suggestion is made by the FTT in this case, which I'll come on to show you, although it's fair to say that the Upper Tribunal adopted perhaps a more benign interpretation of that conclusion. But the point that we say, which emerges clearly from BlackRock, is that there is nothing sinister or inappropriate in advising the directors of a company to leave out of account any tax considerations when those tax benefits, advantages will not affect the company. And it's certainly not a basis on which to justify looking beyond the subjective interpretation, the subjective intentions of the board when deciding to enter into the loan relationship, or indeed the purposes of the wider arrangements. So having identified those errors of law, the court then moves on to remake the decision. And again, we say a number of aspects of its reasoning are informative of the answer in this case. So first, in paragraph 162, the court indicates that a simple starting point in ascertaining a person's purpose for doing something is to consider why they did it. Although Lady Justice Falk does warn against blurring the distinction between motives and purposes. However, what that means in the context of section 442 is why did the taxpayer enter into the loan relationship, not why was the taxpayer as opposed to any other group entity selected as the acquiring entity. And in BlackRock, the answer to that question was simple, as the court explains in paragraph 163. LLC5 became a party to the loans to obtain a tax advantage. And in 164, at the bottom of that paragraph, that's the point I just referred to, its sole raison d'etre was to enter into the loans to obtain tax advantages for the group.
I mean, well, in one sense that was true of you too, wasn't it? The only reason for your company being in existence was to obtain the tax advantage.
Well, no other company acquired the target in our case, so that is the difference in our case. If you're asking why did it exist in the acquisition structure, that is true. But if you're asking what was its purposes for entering into the loan relationship, well, it acquired the target.
And I see that point, but just in terms of this sentence, raison d'etre presumably means reason for being. So the reason for being in the case of LLC,
Yes.
LLC5, was to enter into the loans to obtain a tax advantage. Well, that's true in this case too. The reason for your existence was to enter into the loan to obtain the tax advantage.
Yes, but so coming back to the point that I made a moment ago, in the particular facts of BlackRock, the question why did LLC5 exist and what were the purposes of LLC5 in being party to the loan relationship produced the same answer. And that was because of the specific circumstances of that case, which are set out in paragraph 165 and again in paragraph 171, which I'm about to come on to. So it just happened that that was the outcome, but it was, in our case, why was the appellant brought into existence and put into the acquisition structure leads to one answer, which the FTT and the Upper Tribunal gave you. But if you're focusing on the purposes for which the appellant was a party to the loan relationship, it obviously was a party to the loan relationship so that it could fund the acquisition of LTT.
I mean, a question there is, was there a commercial purpose? But supposing there to have been a commercial purpose, that doesn't of itself mean that there wasn't also a tax advantage purpose.
It doesn't. I'm going to come on to that in due course. But you know, the purpose of the appellant, its raison d'etre, if you want to use that term, was to acquire the target. That is why it was brought into existence, and that is what it did.
Well,
if you ask that of LLC, if
I mean,
you ask
the
that
highest
of,
you can put it, I would have thought, is that the appellant was brought into existence in order to obtain the tax advantage and to acquire the target.
well, there's no tax advantage if it doesn't acquire the target.
Well, there's no tax advantage if it doesn't enter into the loan relationship.
Yes, but it wasn't just entering into a loan relationship and doing nothing with it.
No.
It needed the loan to buy the target, and the consequence of that was it produced a tax advantage.
Yeah.
Which was the idea.
Which was the idea, but the driver behind all of this is the acquisition of the target, and that is not the analysis in BlackRock. If you take LLC5 out of the structure, they achieved their commercial purpose. There was no commercial rationale to LLC5 because it didn't acquire the target. What it acquired was, they're said to be valuable preference shares, but it had no control over that. So it was a device, if you like, to insert debt into, and this is the point I'll come to in a moment, by reference to 165 and 171, in what was otherwise an entirely equity-funded structure and where the target was acquired by another entity. It was a superfluous stage, whereas the appellant cannot be described as superfluous when it is the acquiring entity. So the conclusion at the bottom of 164 that the sole raison d'etre for LLC5 was to enter into the loans to obtain tax advantages for the BlackRock Group is said in 165 to be obvious from the diagrammatic representation. That's why I took you to that at the outset. It was obvious from that structure, which showed that every other level in the ownership structure was funded by equity. It showed that LLC5 had no control over the target. It had no meaningful function. And then at 167, the court accepts there that there was a commercial purpose, namely to fund the valuable preference shares which LLC5 obtained. But it describes that as, in truth, a byproduct of the tax planning. The commercial purpose was necessary in order to ensure that LLC5 was not thinly capitalised. In other words, the tax advantage could only be obtained if there was also this commercial purpose. And then over the page 171, the court says this: I should emphasise that my conclusion that LLC5 had a tax main purpose is a conclusion reached on the particular facts of this case. It does not follow that other debt incurred in connection with a commercial acquisition, as the acquisition of BGI US undoubtedly was, would fall foul of the unallowable purpose rule, even if the decision to borrow had regard, as it often would, to tax considerations. The facts of this case include, among other things, the use of a debt-funded UK resident entity in what is otherwise a wholly US-based and equity-funded ownership chain, the related lack of any commercial rationale for LLC5, and the structure that had to be put in place to ensure that LLC5 did not have control over BGI US Group, such that LLC5 not only had no commercial rationale, but had no real commercial function. Now, we say none of that is true in the present case. The commercial rationale for the appellant was that it was the acquiring entity. The appellant did have real commercial substance in this case. It acquired and then controlled LTT. And every other stage in the ownership chain, in this instance, was debt funded, and the FTT found as a fact that there was a funding shortfall within the group in order to meet the $1.1 billion price tag for LTT. So the next section of the judgment addresses the question of apportionment, and if I may, I was going to return to that when I come on to ground 3. So next, I want to show you the relevant authorities on the question of main purpose. And the first of these is IRC and Brebner, which is behind tab 5 in volume 1.
Do we need to look at what Lord Justice Newey had to say or not?
I wasn't in my submission, the relevant part of Lord Justice Newey's decision is encapsulated by Lady Justice Falk when she says that's a useful starting point to ask why was the appellant a party to the loan relationship.
And you don't object to that question?
No, but we do object to the question, why was the appellant, as opposed to any other group entity, the acquiring company?
Can I be unfair and ask you this question? If I look at section 442, That says that you have to look for the purposes for which a company is a party to a loan relationship.
Yes.
Would you accept or not accept that in this case it would be true to say that the appellant was a party to the loan relationship in order to obtain a tax advantage?
No. I'll move. That's my. I'll come on to that. But no, we say in this order there was no tax purpose. There was a tax consequence, but that was not a purpose of the loan relationship. If there was a tax purpose, it wasn't a main purpose. And if there was a main tax purpose, no part of the debit was properly attributable to it.
I know you say all that. I mean, somewhere there was an intention to obtain a tax advantage.
Absolutely, at the level of, so in relation to the choice of the appellant as the acquiring entity, we accept that there was.
So if I unfairly play around with the stress in the sentence, it was a party to the relationship to obtain a tax advantage.
It being the appellant?
Yes.
No, we don't accept that.
Even though it was chosen so that it could obtain the tax advantage.
Yes, because that was a choice of JGI, the ultimate parent. And as I'll show you in a moment, the purposes of JGI or any other actor in the wider arrangements is not the focus of the test. The test is concerned with the much more precise question of the purposes of the borrower company in being party to the loan relationship.
You accepted when my lord put it to you that there was an intention to obtain a tax advantage.
Within the group, yes.
What is the difference between a purpose and an intention? Because you seem to be placing a lot of stress on this word purpose.
Well,
How do you distinguish that from an intention?
The distinction that I'm trying to draw, and apologies if it's not clear, is that what we say you need to be looking at are strictly the purposes of the appellant, its objectives, its aims in borrowing, in undertaking the loan. The intentions, wishes, purposes even of JGI and other group companies in choosing the appellant, in deciding that the acquisition is going to be made through the appellant, are not the relevant intentions, purposes, whatever.
Quite a lot seems to me to turn on the level of generality at which you ask these various questions. I mean, to go back to Lord Millet, or Mr. Millet's example of the man who pulls the trigger, if you say, well, why do you pull the trigger? One answer is to release the bullet out of the gun. But that's not the relevant purpose. The purpose, Mr. Millet says, is to shoot the person who is standing in the firing line of the gun. So it depends how far back you go for many of these questions.
Possibly, but I would say that the gist, the thrust of what is said in BlackRock is there are all sorts of different purposes tests within the tax code. Some of them look at the purposes of arrangements, a wider scheme of arrangements. And that, I would respectfully say, is what Lady Justice Falk is distinguishing this test from, and saying what this test is concerned with is a much more specific question of the purposes of the borrower company in borrowing.
Well,
and that is it.
But that's not what the statute asks you. It doesn't ask you why did you borrow the money. It asks you why you party to the relationship.
Well,
so it's a stage back from saying why did you borrow the money. It depends on where you break this chain of different motivations, purposes, intentions, call them what you like.
Well, I would say it is asking what is the purpose of the borrower company, what is the objective of the borrower company, what are they trying to achieve with the borrowing? That's all it's asking. It's not asking what are the purposes of the wider arrangements of which the loan relationship forms part. I mean, well, that is what Lady Justice Falk has explained in BlackRock. She draws a distinction between those questions.
And it just, I know you're going to come to this, but if you're looking at what the appellant was trying to achieve by this borrowing, it was trying to get funding to effect the acquisition, but it was also trying to get a tax advantage.
It clearly understood that that is, you know, we're not denying that it was ignorant of the fact that a tax advantage would flow. Of course it would. But if you just focus on the appellant and ask what was it doing by borrowing, it was borrowing to fund an acquisition. And of course, the consequence of that was a loan relationship debit, which it fully intended to surrender to other UK group companies. And we say that is perfectly permissible. So I was going to move on to Brebner behind tab 5. So this was a case concerning the transactions in securities TAR, where the statutory question is whether the transactions have a main object of enabling a tax advantage to be obtained. And in Brebner, the relevant transactions in securities involved the acquisition of shares in a company followed by an extraction of cash reserves by first capitalising those reserves and then carrying out a reduction of share capital instead of extracting those cash reserves by way of a distribution. And the purpose of extracting the cash reserves was to allow the shareholders to repay the debt which had been used to fund the acquisition of shares. And the result of all of that was that the shareholders ended up with a non-taxable return of capital when a distribution, a dividend, would have been taxable income in their hands. So those were the relevant transactions in securities, and the question was whether the resulting tax advantage was a main object of any of the transactions in securities. And the passage that we rely on, which I'm sure you're very familiar with, is at the end of Lord Upjohn's speech on page 68, at letter E. He says, when the question of carrying out a genuine commercial transaction, as this was, is reviewed, the fact that there are two ways of carrying it out, one by paying the maximum amount of tax, the other by paying no or much less tax, it would be quite wrong as a necessary consequence to draw the inference that in adopting the latter course, one of the main objects is, for the purposes of the section, avoidance of tax. No commercial man in his senses is going to carry out a commercial transaction except upon the footing of paying the smallest amount of tax that he can. So what he's saying is that choosing the most tax efficient way of achieving your commercial objective does not mean that tax avoidance is one of the main purposes of the transaction.
Can we just look at another couple of passages in the speeches?
I'm not about to close it,
Right,
but
okay.
We say in the context of section 442, choosing to borrow in order to fund a commercial acquisition because it is more tax efficient, debt giving rise to a loan relationship debit for the interest and equity not giving rise to any such deduction, does not mean that one of the main purposes of the borrowing is tax avoidance. And that is the point acknowledged by Lady Justice Falk in paragraph 171 of BlackRock that we've just looked at. She accepts that commercial acquisitions funded by debt will often have regard to tax considerations, but that doesn't mean that the loan has an unallowable purpose. And we say what the court is rightly acknowledging there is the freedom to choose to fund a commercial acquisition by way of debt and claim an interest debit because it is tax efficient to do that.
In your summary of Lord Upjohn, you've missed out the word necessary, which is italicized in his speech.
I didn't miss it out. I did read it.
You did read it, but in summarising it and making your submission, you left it out. You said it does not mean. It doesn't necessarily mean.
Doesn't necessarily mean. Okay, I take that point. Doesn't necessarily mean. So we say in a scenario where a company chooses to, or a group chooses to make a commercial acquisition using debt and to structure it tax efficiently, it doesn't mean that the main purpose of the loan is to achieve that tax objective. The main purpose of the loan is to fund the acquisition, and any tax objective is of a secondary nature. And we would respectfully submit that the analysis is the same where the acquiring entity is selected with regard to tax considerations. The context is still a genuine commercial acquisition of a target, as undoubtedly the acquisition of LTT was. And in this instance, there was a funding shortfall. So as a matter of fact, the loan was necessary. It wasn't a matter of choice. So we say the fact that the appellant was chosen as the acquiring entity for reasons of tax efficiency does not mean that the loan, to facilitate that objective, has a main tax purpose, an unallowable purpose. The main purpose of the loan was to fund the acquisition of LTT, and any tax objective, which in the event pertains to the selection of the appellant as opposed to any other group entity as the acquiring entity, we say was of a secondary nature. And I also wanted to show you a passage from Lord Pearce's speech, and I hope that's the one that you wanted me to look at. It's on page 65, and it's just above the letter D. And he says, the object which has to be considered is a subjective matter of intention. It cannot be narrowed down to a mere object of a company divorced from the directors who govern its policy or the shareholders who are concerned in and vote in favour of the resolutions for the increase and reduction of capital. For the company, as such, and apart from these, cannot form an intention. Thus, the object is a subjective matter to be derived in this case from the intentions and acts of the various members of the group, and it would be quite unrealistic and not in accordance with the subsection to suppose that their object has to be ascertained in isolation at each step in the arrangements. And I wanted to make 2 points about that passage. First, when Lord Pearce refers to the intentions and acts of the various members of the group, what he is referring to is the group of directors and shareholders. And you can see that if you go back a few pages to page 57, the extract from the decision of the Court of Session, just below letter G.
Sorry, which page were you on?
Page 57, just below letter G. And the Court of Session says, but the respondent and 5 other shareholders were the principal and main shareholders, brackets the group.
Yeah.
So that's the group that Lord Pearce is referring to. He's referring to the group of decision makers of the company in that case. He is not, we would respectfully submit, suggesting that where a company is a member of a group, that the intentions and acts of the other group companies are relevant. It is the intentions and acts of the company's decision makers that count.
Doesn't he mean, rather than going that far back in the judgment, the people identified a few lines up? Maybe it's the same thing, I don't know. Namely, the directors who govern its policy or the shareholders who are concerned in and vote.
Yeah. Yes,
That's what he's talking about, isn't it?
yes, I would agree. The second point I wanted to make was that when he says it would be quite unrealistic to suppose that their object has to be ascertained in isolation at each step in the arrangements, what he means is that where there are multiple transactions in securities, as there were in Brebner, forming a single scheme, the object of each transaction has to be assessed in light of the other relevant transactions in securities. And we say that makes perfect sense in the context of the transactions in securities TAR, which looks at the purposes for which each transaction in securities was carried out. We say that is different to the unallowable purpose test, which looks solely at the purposes for which the company is a party to the loan relationship and not to the wider arrangements of which the loan relationship forms part. So I was going to move on if that's
I
okay.
just
Was there
wanted
another?
to flag up what Lord Pearce says at 64C.
Let's see.
Broad common sense view.
Yeah.
66B to C. Special commissioners could reach a contrary conclusion, which would have been equally unassailable. So this is all a question of fact for the commissioners.
Yeah.
And then your Upjohn 68A to B. Special commissioners could have found there were two chapters.
Yeah.
Essentially a task for the special commissioners.
Yeah. I accept all of that. I readily accept that this is a question of fact, unless there is an error of law, and of course that is the foundation of my case. But I do take that point. And common sense is one of those things that it's very subjective. I would say the common sense points firmly in my favour. So I wanted to go next to Travel Document Service, which is behind tab 19 in volume 2. The question in this case was whether a deemed loan relationship in the form of a shareholding, which had been the subject matter of a swap and then devalued by an ovation of loans to the company. The question was whether that deemed loan relationship, the shareholding, had an unallowable purpose. And so specifically the question in TDS was concerned with the purposes for which the taxpayer held the shares in that case, and whether those purposes included an unallowable purpose. At paragraph 46 on page 421, my Lord Justice Newey concludes that it followed inevitably from the fact that the shares were to be used for the purposes of an admitted tax avoidance scheme, that during the currency of the swap, one of the main purposes for holding the shares was to obtain a tax advantage. And we say, by analogy with that reasoning, where the loan was used to acquire LTT, it follows inevitably from that fact that one of the main purposes for which the appellant was party to the loan relationship was to fund that acquisition. And then he says this between letters H and J. Had the tax advantage in view been small, there might have been scope for argument as to whether an intention to use the shares to achieve it implied that obtaining the advantage was now a main purpose of holding the shares. In fact, however, the hoped for gain was large, both in absolute terms, more than £70 million, and relative to the apparent value of TDS, some £280 million. That being so, I agree with Mr. Ghosh that the inescapable inference was that securing the advantage had become a main purpose of holding the shares. The prospective advantage was of such significance in the context that gaining it must have become a main purpose of holding the shares, as well as of the swap and novations. And then at 48, he says, my lord says, I would add that I do not accept that main means more than trivial. A main purpose will always be a more than trivial one, but the converse is not the case. A purpose can be more than trivial without being a main purpose. Main has a connotation of importance. So the question of whether or not a tax purpose is a main purpose must be viewed in context relative to the importance of or significance of the commercial purpose. And that was the approach adopted by the FTT in Euro money, which is set out in the Upper Tribunal's decision, which we have behind tab 23.
I mustn't speak for my lord, but the context in which these observations are made are the submission that Mr. Peacock puts forward, namely that this was a subject of evidence in front of the tribunal which wasn't challenged. That's why you get this discussion of Brown and Dunn and so forth. And that, I venture to suggest, is why my lord talks about an inevitable inference.
Yes, it's not the inevitable inference that I'm emphasising. It's the point that how you use something is indicative of your purpose.
Yes, indeed. That's what my lord says at 41 Roman 4 can be relevant to what use you make the shares. Yes. Absolutely.
Yes, that's it simply. Can I ask you to turn up Euro money behind tab 23, please? So this arose in a different context. It was a case concerning rollover relief on share-for-share exchange, where the question was whether the exchange formed part of a scheme or arrangements, the main purpose or one of the main purposes of which was tax avoidance. So this is an example of the sort of purpose test which does look at the purpose of the wider scheme of arrangements. And at paragraph 27, the Upper Tribunal notes that on the question of main purpose, the FTT accepted the evidence of the witnesses that tax considerations were not important, and then refers to the decision in Travel Document Service. And then at 28 sub 1, it concluded that the size of the tax advantage, whilst large in absolute terms, was not large in relative terms, being less than 5% of the transaction value. So the FTT, we would respectfully submit there, does exactly what the Court of Appeal has advised in TDS, which is to look at the significance, assess the significance of the tax purpose in the context of the commercial purpose. And we can see, just for completeness, at paragraph 62 at the bottom, the Upper Tribunal endorses that approach.
But this is the same point, isn't it? I mean, if you look back at 27 of the Upper Tribunal records that at 102, the FTT accepted the evidence of Euro money's witnesses that their main subjective purposes were commercial and that tax considerations were not important. So that's the subjective evidence that they accept.
Yeah.
Nonetheless, they go on to say, but looking at the size of it, that can't be right.
Yes.
Effectively. So this is another case of unchallenged subjective evidence being subject to scrutiny by the tribunal in question.
Well, that is absolutely a position in Euro money, but the point that is made in TDS is it is, if you like, an objective assessment of the significance of the values of the tax purpose versus the commercial purpose.
That is undoubtedly relevant.
And in my submission, that is not the exercise or the approach that was taken by the FTT in this case. So what the FTT in this case did was, instead of comparing the significance of the tax advantage against the value of the commercial purpose of acquiring LTT, the FTT compared the size of the tax advantage against an entirely hypothetical scenario in which there was no loan at all. In other words, against nil.
I'm probably muddling myself. I thought the FTT found there was no commercial purpose
Well,
in our case.
it did find that there was no commercial purpose, but it does go on then to talk about was the tax
If there
purpose
was a
the main.
commercial
Yes.
purpose. Yes.
Yeah.
I mean, obviously, as you accept, if there's no commercial purpose, then plainly the tax purpose has to be a main purpose.
Oh, of course, yes, yes. And then the final authority I want to show you on.
Can I just ask you this? You were coming to paragraph 62 of your money. You mentioned that in passing, did you?
I was just pointing out that the very last line of that is the Upper Tribunal's endorsement of the FTT's assessment of Maine, as in relative to the size of the tax saving. So, in other words, a relative assessment of the significance of the purposes. So the final authority I wanted to show you on main purpose is the judgment of Mr. Justice Lightman and SEMA Group, which is behind tab 10 in volume 1.
This is the bit about icing on the cake, is it?
So SEMA, this was a case also concerning the transactions and securities TAR. And in this instance, the transaction in issue involved the purchase and sale of shares by an exempt pension fund as part of a buyback scheme. And where, even though there were good investment reasons for the transactions, they only made commercial sense if the associated tax credits were factored in. And so the question was whether the main purpose of the transactions was to obtain tax advantage in the form of those tax credits. And if we can pick it up on page 158. Towards the bottom of paragraph 52, on 158 is the well-known passage from the judgment of Mr. Justice Cross in Kleinwort Benson, and the key part starts just below letter J. When a trader buys goods for £20 and sells them for £30, he intends to bring in the £20 as a deduction in computing his gross receipts for tax purposes. If one chooses to describe his right to deduct the £20, very tendentiously be it said, as a tax advantage, one may say that he intended from the outset, from the first, to secure this tax advantage, but it would be ridiculous to say that his object in entering into the transaction was to obtain this tax advantage. So the basic point that he is making is that simply knowing and intending that a transaction will result in a particular tax advantage does not mean that obtaining the tax advantage is a purpose of the transaction. And then in 53, Mr. Justice Lightman says this: the observations of Mr. Justice Cross call attention to the need, when determining whether the obtaining of a tax advantage was a main object of an ordinary commercial transaction, to consider with care the significance to the taxpayer of the tax advantage. The tax advantage may not be a relevant factor in the decision to purchase or sell, or the decision to purchase or sell at a particular price. Obviously, if the tax advantage is mere icing on the cake, it will not constitute a main object, nor will it necessarily do so merely because it is a feature of the transaction or a relevant factor in the decision to buy or sell. The statutory criterion is that the tax advantage shall be more than relevant or indeed an object. It must be a main object. So applying that to the present case, for a tax purpose to be the main purpose or one of the main purposes for which a taxpayer is party to a loan relationship, it has to be more than simply icing on the cake, more than simply a feature or a relevant factor in the decision to borrow. It has to be a significant objective. So turning then to the decisions of the tribunals below, can I start please with the diagrammatic representation which is appended to the Upper Tribunal's decision, which is behind tab 6, page 100 of the court.
I'm sorry, Ms. Shaw, I missed the page number.
Page 100.
100. Thank you.
So in this instance, there were 3 links in the ownership chain. And you can see from the blue lines that each stage was part funded by debt. So what this demonstrates was that the group needed to borrow in order to fund the acquisition of LTT. Then you can see that the appellant appears, JTI Acquisition Co, appears at the bottom of the chain and is the acquiring entity. And that, we say, was the commercial rationale of the appellant. It acquired and as a result controlled LTT. It was not a commercially redundant conduit. 2 more points before we leave this page. First, after the loan between JTI and the appellant was entered into, you can see that JTI assigned its interest to a Cayman company. Now, as the Upper Tribunal explains in paragraph 12 of its decision, this was to ensure that the interest debit was not disallowable under the UK's anti-arbitrage code, which applied in the case of any mismatch in the tax treatment of the interest receipt. And as a result of this box around the 3 companies, the appellant, JTI and Joy Cayman, that box indicates that for US tax purposes, those 3 companies are treated as a single entity, so transactions between them were to be ignored. So that meant that the receipt of the interest by JTI would not have been taxable.
And just remind me, the top company originally contracted to buy LTT.
Correct, yes, Joy Global Inc., yeah.
Was there any reason for any of these other 3 companies to get involved except tax?
So was there any other reason for the acquisition structure?
But was there any reason for the acquisition not being affected by the top company which had contracted to buy LTT?
So various, you'll read in the FTT, various points were put forward to explain the rationale for choosing the appellant, and the conclusion that the FTT reached was that there was the only rationale for choosing the appellant was to obtain the tax advantage, and we're not challenging that.
No, I suspect I'm just not remembering very well what the FTT said, but broadening it from just our company to the 3 companies that are interposed between the top company and LTT in circumstances where the top company had contracted to buy LTT. Was there any reason for the involvement of any of these three companies except tax?
I can't be sure. I'm not sure I know the answer to that, but I suspect that there were US tax reasons for having, you know, why Joy Global Inc., for example, didn't just incorporate a UK subsidiary. I imagine was for US tax purposes, but I wouldn't want to be absolutely quoted on that. Oh right, yeah. I think the answer, I'm being passed a note saying that they wanted an SPV, they wanted a clean company to make the acquisition, but I don't know why.
There's something in blue writing under the box, the big box encompassing single entity for US tax purposes.
Yes.
Is that relevant?
So that's the reason why there was so the interest receipt. If JTI had not assigned the loan note to Joy Global, the payment of interest by the appellant to JTI would not have been taxable under US tax law because those two companies are a single entity. So you ignore transactions between them under the US tax code. So the assignment to Joy Global was intended to ensure that the anti-arbitrage rules, which would apply to in the case of a mismatch between the deduction of interest and the non-taxation of the receipt, to ensure that that code was not engaged because, well, under the anti-arbitrage code, there was a carve-out for situations in which a mismatch in the treatment of interest it arises as a result of local tax law. So if under Cayman law, as is the case, interest is not taxable, so no interest receipt is taxable under Cayman tax law, because of that, the anti-arbitrage code does not apply. So that is a specifically provided for exclusion in the anti-arbitrage code. And the point that I want to make about that is that the assignment of the debt to a Cayman company in order to ensure that the carve-out applied, it has never been suggested that the assignment of the loan was in any way abusive or contrary to Parliament's intention that mismatches arising as a result of local tax laws should be excluded from the code. So the assignment has never been challenged on that basis. The second point I wanted to make is that to the extent that the non-taxation of the interest receipt constitutes a tax advantage, it's a Cayman tax advantage or a US tax advantage. And the Upper Tribunal acknowledges in paragraphs 15 and 80 that these tax advantages are irrelevant for the purposes of the unallowable purpose rule. So we are solely concerned with whether there is a UK tax main purpose. So we would respectfully submit that the oddity, if there is one in this case, is not in the deduction of interest by the appellant, being interest on a loan used to fund a commercial acquisition. The oddity is in the non-taxation of the interest receipt, and that is not a relevant concern in applying the unallowable purpose rule. It is a concern of the anti-arbitrage code, and as I've said, there is a specific carve-out for mismatches which arise as a result of local tax laws. So turning then to the FTT's decision, which is behind tab 11 of the core. And our first ground of appeal, which is that instead of asking what were the purposes for which the appellant was party to the loan relationship, the FTT focused on the reasons or purposes for which the appellant, as opposed to any other group entity, was chosen as the acquiring entity. And can we pick it up, please, on page 35, under the heading, was securing the tax advantage a purpose? So in the final sentence of 143, the FTT says, the specific question I asked, therefore, is what was the purpose for which the appellant, in issuing the $550 million loan notes to JTI? And we say, so far, so good.
That's the right question.
That's the right question. Yeah, we agree. Then in paragraph 144, the tribunal observes that the relevant purposes are to be established by ascertaining the subjective intentions of the relevant decision makers. And again, we say nothing wrong with that. Then in paragraphs 146 and 147, the FTT sets out two guiding principles, which it derives from Lord Pearce's speech in Brebner, and which we say demonstrate that what the FTT is really concerned with are the subjective intentions of the relevant decision makers that resulted in the appellant, as opposed to any other group entity, being selected as the acquiring entity and entering into the loan relationship.
So at this point, you say the FTT went wrong.
Yeah. So the first guiding principle in 146 is that the purposes for which the appellant was party to the loan relationship must be determined by reference to the overall scheme or arrangements. And as I explained a moment ago, the observations of Lord Pearce in Brebner have to be understood in the context of that case. What Lord Pearce means when he says it would be quite unrealistic to suppose that the object of a transaction has to be ascertained in isolation at each step in the arrangements, or what he's referring to there, is a scenario in which there were multiple transactions in securities which formed a single scheme, and where the statutory test requires the purposes of each of those transactions in securities to be ascertained. But we say that that is not the right approach in the present case, and as the court explains in paragraph 107 of BlackRock, what the unallowable purpose test is concerned with is the purpose for which the taxpayer is a party to the loan relationship, and not the purposes of any wider scheme or arrangements of which the loan relationship forms part.
So this is the passage in Brebner which we were looking at
Yes.
a moment ago,
Yes.
when you were referring to the phrase members of the group.
Yes.
We had an exchange there, you will remember.
Yes.
And what the FTT is saying in 146 is the phrase the object of the directing minds of the appellant. As we
Well,
ascertain in isolation.
so what it says at the bottom of 146,
Yes.
the FTT says the object of step 6, which brought into existence the loan relationship, is to be found by reference to the overall scheme. And I'm taking issue with that as a guiding principle. And the point that I made 2 points, you'll recall, in relation to Lord Pearce's speech in Brebner. First, I said, the first point I made was about what he meant
In
by
fact,
the group.
the point I'm coming to is no doubt going to be your second point.
Yes,
So pause. Come back to me in a minute.
yes.
Okay.
I will do. But I say that first principle relies upon a misreading of what Lord, or a misconstruction of Lord Pearce's speech in Brebner, because in Brebner, what Lord Pearce was looking at was multiple transactions in securities and applying a statutory test which asked what are the purposes for each of those transactions in securities.
Well,
And-
the peg for what the tribunal is saying is 4421B.
Yes.
That talks about purpose for which the company enters into transactions which are related
Yes.
transactions by reference to. But I don't think we've been shown, have we, what related transactions means?
I don't think we've got that in the bundle, actually. It's defined, and this is my second point about why the first principle is wrong. Not only, I say, a misconstruction of Brebner, but also the reliance on 4421B, because the reference there, and this is something that the Upper Tribunal accepts, was an error on the FTT's part. The term related transactions in 4421B is a term of art defined in section 304 of the CTA 2009. It might be in the Upper Tribunal decision, actually.
304, did you say?
304, yeah. If we just turn up quickly paragraph 6 of the Upper Tribunal's decision. You can see there the definition of related transaction is any disposal or acquisition of rights or liabilities under the relationship. And it was common ground that there were no related transactions in this instance. So the Upper Tribunal accepted, and we say it was right to do so, that the reliance on related transactions was an error in this case. So we say that the first guiding principle is based on a misreading of Brebner. It erroneously relies on section 4421B's reference to related transactions. And moreover, we would submit that it is unsustainable in light of paragraph 107 of the judgment in BlackRock, which we say makes plain that what the statutory test mandates is an assessment of the purposes for which the taxpayer is a party to the loan relationship, and not the purposes of the wider arrangements of which the loan relationship may form part. So the second guiding principle is that the object or purpose is a subjective matter to be derived from the intentions and acts of the various members of the group. And again, I would respectfully submit that is predicated on a misreading of Lord Pearce's speech in Brebner, because when he refers to the group, he is talking about the decision makers of the company and not group companies.
So you're saying the FTT misidentified the group, the relevant group?
Yes, yes. And we say that the FTT also relies on a misreading of the dicta in Garforth and Tankard Carpets and Vodafone, which set out in 148 and 149. In Garforth, the question was whether expenditure incurred by the taxpayer company on securing the debt of another group company, which was a general benefit to the group, was incurred wholly and exclusively for the purposes of the taxpayer company's trade. And as Mr. Justice Walton explains in the passage set out at the bottom there, if the interest of all three companies were considered together when the vital decision was made, when the expenditure was incurred, then it would be extremely difficult to say in whose best interests, or rather in whose exclusive interests, the expenditure was incurred. In other words, all he's saying is expenditure incurred by one group company is not wholly and exclusively for the purposes of that company's trade, where it also serves the purposes of the trades of other companies, and it was incurred with that objective in mind.
Doesn't it amount to a question of fact, though? Are you saying that members, that persons outside the immediate directors of one company can never be the the persons governing the policy?
No, of course it does depend on the facts, and I'll come on to that in a moment,
Okay.
because
So you-
there was a conclusion by the FTT about the independence of decision making within the appellant company, and I do want to address you on that point. And I'll make a point about when it is appropriate to look at the purposes of other actors as illustrative or helpful in ascertaining the purposes of a company. So
Is there an error in 147? And in a sentence, if there is, what is it?
the error in the second guiding principle is that in ascertaining the purposes of the borrower company for being party to the loan relationship, what you are concerned with, unless there is a basis otherwise, but what you are concerned with, what you're trying to identify, I'm losing my wig, I'm so sorry, is the subjective intentions of the company's decision makers. And I'll say a bit more about that in a moment, but the error in the FTT's approach is that they thought that they could look to the subjective intentions of the wider group and the purposes of the wider arrangements in identifying the relevant purposes for section 442. We say both those principles are wrong. So in 149, the FTT relies on Vodafone. The point in Vodafone was that, if you like, it was the opposite outcome to Garforth. In Vodafone, the mere fact that the expenditure in question was of benefit to the group didn't mean that it had been incurred wholly, or didn't mean that it had not been incurred wholly and exclusively for the purposes of the taxpayer company's trade. And that's the point that Millett makes, or Justice Millett makes, when he says this was an obligation solely of the taxpayer company. The fact that it was of wider benefit to the group did not alter the fact that when incurring the expenditure, the company only had in mind its own interests, its own purposes. So we say neither of those cases, Garforth or Vodafone, is authority for the proposition that a company's purposes are to be derived from the intentions and acts of the various members of the group. And again, we would respectfully submit that the FTT's second guiding principle is unsustainable in light of paragraphs 106 and 107 of the judgment in BlackRock, where the court confirms that the relevant purposes are those of the borrower company and not other actors or group companies. So we say both of those guiding principles are wrong in law and are material errors of law, because instead of focusing on the purposes for which the appellant was a party to the loan relationship, the FTT looked at the purposes of the group in choosing the appellant as opposed to any other group company to be the acquiring entity.
Does that mean you can get round the finding of fact at 153? FTT finds there was no genuine decision making at the UK level.
Can I come to that in a moment? I am going to come on to that. So just to finish off the error of law, the errors of law that we marked on, and for the avoidance of doubt, it's not to say that the purposes of other group companies can never be informative of the taxpayer's purposes in being party to the loan relationship. And this is the point that we make in paragraphs 30 and 31 of our skeleton. In circumstances where the appellant is giving effect to a group plan, it may be relevant to have regard to the intentions and purposes of other actors, other group companies, but always with a view to identifying the appellant's purposes for being party to the loan relationship. So, for example, the purposes of JGI in entering into the stock purchase agreement are informative. The purposes for which JGI borrowed from a third-party bank are informative. The purposes for which JGI selected the appellant are not, however, informative in our submission of the purposes of the appellant in entering into the loan relationship. Whilst that might explain the appellant's existence or presence in the acquisition structure, we say paragraph 107 of the decision in BlackRock makes clear that that is a different question. So that then brings me to doesn't quite bring me to ground two. So 152. This is the under the heading findings of fact, and I will return to these when I do come on to ground two. But I just wanted to finish off on the errors of law, my ground one, by showing you paragraph 153. And I'll just ask you to read that paragraph to yourselves, please. So there are two parts to 153. First, it is said there was no genuine decision making at the UK level as regards the resolution to issue the $550 million loan notes to JTI. And the factual basis for that contention is summarised in subparas 10, 11 and 12 at the top of the page. In short, the FTT decides that the contents of the board memo, the board pack, and the board meeting were designed to give the illusion of independent decision making and disguise the existence of a tax purpose. So this is very similar to the observations of the Upper Tribunal in BlackRock, and which Lady Justice Falk described as inappropriate in that case. And we say it is true that the appellant's directors were advised by the Dehenny memo, which is set out in paragraph 66 of the decision, to consider the transaction on its own merits only, and not to give consideration to any broader benefits that may be derived by the group. But as paragraph 154 of the judgment in BlackRock explains, this is entirely proper in circumstances where the appellant would not itself benefit. And so we say that there were sound reasons for Mr. Wagner to send the email set out in paragraph 57, requesting that the tax planning matrix be removed from the board pack. And we say the fact that the board minutes had been pre-drafted by Eversheds and that the directors had already been through the thinking process in advance of the board meeting is perfectly commonplace in corporate decision-making processes. So we say that none of those factors, sub 10, 11 and 12, was an appropriate basis on which to conclude that there was no genuine decision-making at the UK level.
So that's an Edwards and Bairstow challenge.
It's an Edwards and Bairstow challenge, yeah. Quite the reverse, and I'll show you in a moment what the Upper Tribunal has to say about that. In essence, the Upper Tribunal agrees and says, well, that's what they say, but they can't possibly have meant that, and repositions what the FTT says in that first part of 153. And we say quite the reverse. What the evidence showed, and the Upper Tribunal records in paragraph 140 of its decision, Mr. Olson's unchallenged evidence that the appellant's board took its own independent action to satisfy itself that it was acquiring a good investment.
Sorry, that's 140
40
of the FTT.
at the Upper Tribunal, yeah, I'll show you that section of the decision, but you'll see that essentially the Upper Tribunal repositions that conclusion. And then the second part of paragraph 153 concerns the objects of JGI in implementing the Deloitte scheme and the purposes for which the appellant exists. And as I've said now, we say those are not the relevant purposes, as the court explains in paragraph 107 of BlackRock.
So just to be absolutely clear, you say that the reason for the company's existence isn't determinative. The fact that it's been chosen for a tax reason isn't determinative. If though the board of the appellant chooses to enter into the loan relationship both because the money is needed to effect the acquisition of LTT and because they wish to further the group's objective of obtaining the tax advantage, then there isn't a tax purpose.
If their purpose in doing that, if their purpose in borrowing is to obtain a tax advantage for the group, then obviously I accept there is a tax purpose. But then you have to ask, was that a main purpose? And that's the context and so on. But my first argument is there is not, on the facts found, there is not a tax purpose.
And I suppose I'm just trying to isolate how far it's dependent on the facts found. So if you had a situation where the appellant had been chosen to be the borrower for tax reasons, and its board knew that and entered into the loan relationship both because the money was needed to effect the acquisition and because it wished to further the group purpose of getting the tax advantage, then there would be a tax purpose.
Well, I would submit that if the appellant appreciates that the reason why it has been offered this commercial opportunity, which involves borrowing, is because it is tax efficient, that does not give the appellant a tax purpose. I would say that is the reality of what has happened here. The appellant has been offered the commercial opportunity, and it has taken that opportunity, assessed it on its commercial merits, and in doing that it knows that a consequence will be to generate a tax advantage for the group, but that is not the appellant's concern. That is not its objective in borrowing. It understands that that will be a consequence of it.
Was it open to the appellant to decide not to proceed with the transaction?
Yes. Yes, it was.
So can I just isolate where the distinction comes? You say, well, the tax position wasn't its concern. Let's just suppose that the directors choose to borrow the money both because they need it to effect the acquisition and because they desire to advance the group purpose of obtaining the tax advantage. Now you say, well, that's not their concern, but it is in the sense that they desire it. Do they then have a tax purpose? Leave aside whether it's a main purpose, do they have a tax purpose?
Sorry, I missed you said something about they deserve it.
Desire, sorry.
Desire it. So if the appellant wants to borrow in order to generate a debit, if that is its objective, or one of its objectives, then I accept that is a tax purpose, yes. Yes. But simply doing something, knowing that that is what will happen, that is the point that Mr. Justice Cross makes in Klein-Walt-Benson. And there's a little bit of sleight of hand, actually, in SEMA, completely unintentional, I'm sure. But the point that Mr. Justice Cross is making is doing something knowing that it is tax efficient does not give you a tax purpose. And Mr. Justice Lightman says what that observation calls it or requires you to do is consider very carefully whether it's a main purpose. Actually, what Mr. Justice Cross is saying is it's not a purpose. It's a consequence, it's an outcome, but doing something tax efficiently doesn't give you a tax purpose.
Can I try to isolate things again? So now we'll move away from the appellant to the wider group. Now, would you accept that the wider group had a tax purpose?
Yes.
So in that sense, the Mr. Justice Cross analysis wouldn't come in at that level because plainly they're not proceeding on the basis that this is just something they know that's going to happen. That's what they're about.
Well, yes, they also had a commercial purpose.
Yeah, no, quite. So that's a question of main purpose. But the Mr. Justice Cross analysis, you say, well, Mr. Justice Cross says, well, it's not a purpose at all. It's just something that's going to happen.
Yeah.
But that's not what the wider group was about. It was structuring this to achieve the tax advantage.
Yes, it wanted to acquire the target and it wanted to create a loan relationship debit. Yes.
Yeah. Yeah.
Seems to me that the approach to statutory construction which you are advocating really turns the clock back to the Duke of Westminster's case and ignores all the sort of Ramsey line of authorities that have intervened. So you mustn't look at the group, must only look at the appellant, mustn't look at the context in which the appellant came into existence. You must just look at what was in the minds of the directors when they signed up to the loan.
Well, I would completely disagree with that. What the legislation has, the legislation could have been drafted more broadly. It could have said, what are the purposes of the arrangements of which, the loan relationship or the arrangements, wider arrangements of which it forms part. It absolutely could have said that, and I wouldn't be standing here arguing about it. But the very point that is made in 107 of BlackRock is this is a specifically targeted purpose test which attaches to the purposes for which the appellant, the borrower, entered into the loan relationship.
It's crucial to your case that you focus on the intentions of the borrower. As a matter of fact, the statute is expressed in a more passive way. It says the purposes for which the company is a party include a purpose. Well, as a matter of language, that's obviously the case, surely. The purposes for which the appellant is a party include a tax purpose.
But then you end up with a slightly odd starting point where every single loan relationship has a tax purpose, and then you're just looking at whether or not it's main. And that seems quite a surprising starting point, and that's again the point that Lady Justice Falk makes in BlackRock. It can't just come down to a question of, is the tax purpose a main purpose?
Yeah. Yes.
So, sorry, I've lost my place. I think I was moving on to the heading, what evidence of business or commercial purpose, which is at 155 over the page. And I say these errors of law also manifest themselves under this heading. So under this heading, you can see that the FTT is addressing the putative non-tax purposes which are set out in paragraph 102. And if we just return to paragraph 102, we can see that these are various non-tax advantage considerations to support the use of a UK company for the LTT acquisition. So in other words, these are the reasons or the purposes for choosing the appellant as opposed to any other group entity as the acquiring entity. So again, my point is that that is focusing on the wrong purposes. However, in paragraph 157, in the second sentence, the FTT accepts that there was a bona fide commercial reason to acquire LTT, and says the business case was eloquently set out in the Project Longhorn presentation by Merrill Lynch.
Sorry, where are you now?
We're in 157, second
Yep.
sentence. So accepts bona fide commercial reason to acquire LTT. But then it goes on to say that the appellant contributed nothing to the negotiation in closing the purchase of LTT. And then at the bottom, crucially, the sinews between the commercial case to acquire LTT by assignment are absent to enable any finding of fact that the commercial case to acquire LTT would necessarily be extended to making the appellant the purchaser, which entailed the assumption of the loan from JTI, a commercial purpose without more. So again, the FTT is focusing on the purposes for which the appellant, as opposed to any other group entity, was selected, instead of the purposes for which the appellant was party to the loan relationship. And in any event, we say that the distinction which the FTT draws here between the commercial purpose for acquiring LTT and the purposes for choosing the appellant as the acquiring entity are artificial. The choice of the appellant as the acquiring entity did not take place in a vacuum. It was not a separate and unconnected event. It was entirely dependent and consequential upon the decision to acquire LTT. It was, in essence, how the commercial decision was to be given effect to. Then over the page, under the heading, the positive case, that obtaining the UK tax advantage was a main purpose. The FTT here observes that JGI was already locked in.
Sorry, I've lost you.
I'm paragraph
Right.
167.
Yes, that's it.
So the FTT says JGI was already locked in to complete the stock purchase agreement, and then describes the Deloitte scheme as bolted on to the LTT purchase agreement for no other reason but to obtain the UK tax advantage. So again, we say the FTT is erroneously focusing on the purposes of the wider arrangements as opposed to the purposes of the appellant for being party to the loan relationship. And again, in any event, we say that the description of the Deloitte scheme as bolted on to the LTT purchase agreement is not a fair description. As I said, the Deloitte scheme is the how to the LTT purchase or the LTT stock purchase agreements what. The first agreement tells you what they want to do, and the Deloitte scheme tells you how they're going to do it. At paragraph 170, the FTT relies on certain post-completion events which are said to demonstrate that the appellant's sole purpose for being party to the loan relationship was to obtain a UK tax advantage. And again, we say on closer inspection, it's apparent that those are all concerned with the purposes of the wider scheme or arrangements. So the first item relied upon there is Mr. O'Brien's explanation to LTT's insurer, Global Commercial Credit LLC, and that is set out in paragraph 79, which we might just briefly turn up. And in little 3, you can see there that what he's referring to is the assignment of the loan note by JTI to Joy Cayman. So this has nothing to do with the appellant, still less the appellant's purposes for being party to the loan relationship. Then the second factor in paragraph 170, second and third, in fact, concern a presentation which Mr. Olson.
Sorry, I'm getting muddled. So the two companies, the entities referred to in paragraph 3 and paragraph 79 are which?
They're the other two. They're concerned with the assignment of the note receivable. So prior to that, the note receivable was held by JTI, so the appellant's immediate parent company, and JTI assigned the loan note receivables to the Cayman company, Joy Cayman.
So just to be clear, the Cayman Islands entity holds a note receivable from the UK entity.
Yeah.
There are no employees or tangible assets in either entity. So is that including the UK entity?
Well, it's clearly wrong if it's including the UK entity, because the UK entity holds the shares in LTT.
As a matter of language, it looks as though it would include the UK entity.
I agree with that, but it's obviously factually, if that's what he meant, that's not, he can't have meant that the appellant has no assets, because that's just not right.
No.
So the assertion in 170, subparagraph 1 is wrong. Is that what you're saying?
I'm not saying it's wrong. I mean, that's what, it's a reference to that communication. My point is that is a factor concerned with other actors in the arrangements. And my essential point is the purposes with which we are concerned are the purposes of the appellant in entering into the loan relationship. That JTI subsequently assigned the loan note receivables to Joy Global is not, are not the purposes of that, or the fact of that is not informative of the appellant's purposes.
And
they might go to the wider arrangements, but that's not what we're concerned with.
I do follow the point you make about 3, but just so I understand it, if the reference to tangible assets included physical things, or referred to physical things, that would be right, would it?
Yes, it would, yes.
So the appellant didn't have any employees and didn't have any physical things.
It was a holding company, exactly.
Yeah, and I can't remember what is said about this. Is there any reason to believe that the appellant was ever going to do anything in relation to LTT, or was the reality that LTT was going to be managed elsewhere in the group?
I don't think there's any evidence on that. There was certainly no, I don't think there's any suggestion that the appellant would become an operating company, for example. It was and remained the holding company.
I mean, that might be consistent with the idea that what the appellant's role was to implement the group's intentions, both in buying LTT and in obtaining the tax advantage in doing so.
What, the assignment of the...
Sorry, coming back to the entering into the loan relationship. I mean, if the truth is that the company is buying LTT, but it's not going to do anything with it, it's just serving the group's purposes, then why isn't it serving the group's purposes both in effecting the acquisition and in doing so in a way that gets the tax advantage?
Well, it's common ground that the appellant is a was offered the opportunity to make the acquisition in the knowledge and with the intention that it would create a loan relationship debit. My point is that that doesn't mean that the appellant had a tax purpose. What the appellant was looking at was the commercial soundness of the opportunity. It understood it was going to be a holding company, just like any other holding company, and acquiring an operating group. And that was the decision that it made. It looked at the overall commerciality of that. It doesn't undermine the substance of the appellant in the way that it doesn't undermine the substance of any holding company.
Yeah.
But my point on subsection 1 of 170 is it's looking at the purposes of the wider arrangements, not the purposes of the appellant in entering into the loan relationship. Then items 2 and 3 under paragraph 170 are concerned with a presentation which Mr. Olson, who was the group CFO, made to JGI on global tax strategy. And again, I say that whilst that might be informative of JGI's purposes in choosing the appellant as the acquiring entity, it's not informative of the appellant's purposes for being party to the loan relationship. The fourth item in paragraph 170 is the quantification of the tax advantage to the JGI board. And again, we say if it's informative of anything, it's informative of JGI's purposes. But in any event, simply knowing and intending to bring about the tax advantage doesn't make it a purpose or main purpose. The fifth item there is dual tax benefits presented by Mr. Olson, again to the JGI board. So informative of JGI's purposes perhaps, but not of the appellant's purposes in becoming party to the loan relationship, and any non-UK tax benefits are irrelevant for our purposes. The sixth item relied upon is Mr. Kiston's concerns about good governance, and these are recorded in an email which is set out in paragraph 82, where he says at the bottom of the page, for the sake of good governance, we need to undertake board meetings and preserve the tax benefits. And we say that whilst this at least has the virtue of focusing on the appellant, what it indicates is the director's primary concern that the company should practice good governance. And that the preservation of tax benefits was regarded as being consequential upon the practice of good governance. And then the final item in paragraph 170, sub 7, is JGI's request that no interest be paid in the 2011 accounting period so as to not impact the US tax position. So again, we say this is concerned with JGI's purposes, and in any event, it concerns US tax considerations which are not relevant for present purposes. So we say none of those factors support the proposition that the sole purpose for which the appellant was party to the loan relationship was to obtain a UK tax advantage, but more importantly, they demonstrate that what the FTT was focused on were the purposes of JGI and the purposes of the wider arrangements, which is not the focal point of the Section 442 test. So then at 171, the FTT describes the loan as lacking genuine commerciality because of the interest deferral and the funding of interest payments by way of further loan notes. And in our submission, there is no factual basis for impugning the commerciality of the loan. In particular, the deferral of the interest and then its funding by way of further loan notes demonstrates that it was a genuine debt with real financial consequences. And it is, of course, not in dispute that the loan was made on arm's length terms.
What do you say about the last line of 171? Does that have any relevance to your argument?
Since it was an empty company, it did not have the means to generate income to service the loan.
That's said to be a factor indicating a lack of genuine commerciality of the loan agreement.
Well, I mean, I don't really understand what the FTT is saying there, because it obviously wasn't an empty company. It held the shares in LTT. But if it means that there weren't any dividends in the period to fund the interest payments, so what? You know, the interest was due and it was met by the issue of further loan notes, but that's just a timing question around the payment of dividends. Perhaps there was a cash flow issue within LTT. I don't know, but I don't think it's right to describe it as an empty company. So then over the page 174, this is where the FTT addresses the question of whether the tax advantage was a main purpose in relative terms. And it says here that the relevant comparison is between the anticipated UK tax advantage, which was $6.3 million over 10 years, and nothing at all, which would have been the outcome of not implementing the Deloitte plan. And in our submission, that is plainly the wrong approach. The point of the exercise is to assess the relative significance of the tax advantage against the significance of the commercial purpose. However, by focusing on the wrong purposes, the FTT failed to identify the commercial purpose for which the appellant was a party to the loan relationship, namely to fund the $1.1 billion acquisition of LTT. And we say, applying the approach in TDS and euro money, the correct comparison is between the value of the tax advantage and the value of the commercial acquisition. So instead, what the FTT did was to assess the significance of the tax advantage against the hypothetical scenario in which there was no loan at all. And on that approach, the tax advantage will always be a main purpose because the comparator will always be zero.
I don't think the FTT is comparing with no loan. I think the FTT is comparing it with no loan to the appellant, i.e. to a UK company.
Well, that's true. Relative to not implementing the scheme, yeah. But if you're going to adopt that comparison, then, you know, self-evidently the answer will always be the tax advantage is the main, a main purpose, because you're comparing it against zero. So then the final section deals with the question of attribution, and I'll return to that when we come on to ground 3. If you can pick up the Upper Tribunal's decision, please, it's tab 6. So the first issue was whether the FTT had erred in its approach to the unallowable purpose test. And in paragraph 32, the Upper Tribunal notes here that the key provision is section 442, which asks whether the purposes for which the company is a party to the loan relationship include an unallowable purpose. And then it asks, did that encompass looking at why the particular company as opposed to another company was a party, or was it restricted to the purpose for which the company was a party in the sense of the reason why the particular company entered into the borrowing? And in our submission following the BlackRock, we say it's now clear that the question with which Section 442 is concerned is the purposes for which the company was a party to the loan relationship, and not why the particular company as opposed to another company was a party. And then we can see that error essentially the conclusion that the Upper Tribunal reaches is that it should be looking at the reasons, the purposes why a particular company as opposed to another company was a party to the loan relationship, and we can see that in paragraph 35 over the page.
35 is pretty much the same question that BlackRock posed. But I suppose it may depend on where you put the emphasis in the phrase. You want to say the question is why are you a party to the loan relationship?
Yes.
Whereas this is asking why are you a party to
Yes.
the loan relationship?
That's exactly it. Yes. Yeah. And that's the point. I said when we looked at BlackRock, I said I don't take issue with Lord Justice Newey's starting point, but what the why attaches to the loan relationship, not why are you in the acquisition structure? Why do you exist? And why did you enter into these wider arrangements and so on? Then in 36 we see it, again nothing in 441 or 442 precludes consideration of why the taxpayer company as opposed to someone else is a party to the loan relationship. Paragraph 37 over the page, at the end of that paragraph, it instead asks why the taxpayer is a party to the loan relationship, which on a natural interpretation covers both the question of why the taxpayer undertook the borrowing, but also questions of why the taxpayer as opposed to someone else was a party. Again, at the bottom of 38, you can see it thus leaves open the question of whether one can ask why are you as opposed to someone else a party. Again, in paragraph 42, there is no indication in the statutory wording that when assessing the company's purposes, it will be irrelevant to consider the circumstances in which the company was chosen to enter into the relationship, or the parent company or group benefit related reasons for that company entering into that relationship. Again in 44.
Just coming back to 42, can I work out how far you do quarrel with what the Upper Tribunal says there? Because they go on to say that is not the same as saying another company or the group's purpose is viewed as determinative. Well, that's consistent with BlackRock. Rather, the other company's group's perspective is relevant to the taxpayer company's purpose because it informs the determination of the particular taxpayer company's purpose. Now, do you disagree with that?
Well, what the Upper Tribunal doesn't explain is how or why those things are said to inform the taxpayer's purposes for being party to the loan relationship. And that's really the point in BlackRock. Lady Justice Falk explains what the particular circumstances of that case are and why the answer to why does the company exist is the same as its purposes for being party to the loan relationship.
Are you saying that's contrary to what the Justice Falk said in 107?
Yes, my submission is that the point she is making is that they are different questions. They might produce the same outcome if the particular facts justify it, but she's going out of her way to say those are different questions. If she thought they were the same question, she wouldn't have bothered to make the point in 107.
But if we look, say, at paragraph 164 of BlackRock,
Yeah.
seems very much in keeping with 42 of the Upper Tribunal.
Yeah, but she goes on to explain what you can't read 164 on its own. The reason why she reaches that conclusion is explained in 165 and 171. It's the particular circumstances of the case. There was no other commercial rationale was commercially redundant, and therefore the question, what were its purposes in being party to the loan relationship, yielded the same answer as why did you exist? Its sole raison d'etre was to enter into the loans. She reaches the same outcome as the Upper Tribunal, but she criticises the Upper Tribunal for focusing on the wrong purposes without explaining why they were indicative of the purposes for which the company was party to the loan relationship. And that's what she's doing in 165 and 171, is explaining what those purposes are, which, yes, yield those questions yield the same result. And so unless there is an explanation as to why the facts of this case do that, in my submission, the point is she is explaining in BlackRock that the focus is on the purposes, and you'll never go wrong if you focus on the purposes for which the company is party to the loan relationship, and that is manifestly not what the FTT and the Upper Tribunal did below.
But, well, this is a bit irrelevant, but 42, that's all fine on the face of it. It's not the same as looking at the group's purpose. The group's perspective is relevant so far as it informs the taxpayer company's purpose.
Well,
May be relevant so far as it's full.
Or may be relevant.
it may be relevant, but it doesn't go on to explain. That the point is, when you look at its reasoning in totality, it doesn't go on to explain why that is informative of the purposes of the appellant in entering into the borrowing.
Isn't this partly what Lady Justice Falk is addressing at paragraph 166 of BlackRock? Context.
Yep, she's focusing on the particular circumstances in BlackRock. I mean, that's my case really, is that the outcome, she's at pains to point out in BlackRock that the outcome turns on the particular facts in that case.
The factors A and B at paragraph 166 are equally applicable to this case, aren't they? You've got a US company acquiring another US company.
No, B is not applicable to us. So the point in BlackRock was that
JGI is locked in by contract to acquire LTT, and this is all interposed in between contract and completion or closing, isn't it?
Well, that is all true, but that's not a point she's making in B here. The point she's making in B is, if you look back at what was originally proposed by EY, it was that LLC 5 would be the acquiring entity. And then there were issues around LLC 5 owning the US group. And so for that reason, LLC 5 got preference shares, which carried no right of control over LLC 6 or the target. So that's what she's referring to there when she talks to variations in the structure. It was the original proposal by EY was LLC 5 would be the acquiring entity, and that couldn't happen. And that was what demonstrated the commercial redundancy of LLC 5.
So if that had happened, the result in BlackRock might have been different.
That's what she means when she says it's the particular, in 171, it's the particular facts of this case. The LLC 5 had no commercial function, and that is not the case here. Then again in 44, the Upper Tribunal says that, again, the natural reading of 442 allows for considering why it was the particular company was chosen to be a party. Over the page, paragraph 45, the Upper Tribunal refers to 442 sub 5 as indicating that one must be able to look outside the company in order to ascertain purpose, and that facts pertaining to other persons might include the reasons why the company was set up, which in turn might inform the company director's understanding of purpose. And then in 46, the tribunal is not prevented in ascertaining the purposes for which the company is a party from considering the wider facts and circumstances surrounding the establishment of the company. These may include why the appellant was a party to the loan relationship as opposed to someone else. And in our submission, we would respectfully submit that those conclusions are inconsistent with what is said in BlackRock, where the judgment explains the purposes for which the company is party to a loan relationship should not be confused with the purposes for which the company exists or the purposes of a wider scheme of arrangements of which the loan relationship forms part.
I mean, just, I suppose, going back to the sort of conversation we've just been having, if you look at 45 and the passage you quoted, those facts might include the reasons why the company was set up, which in turn might inform the company director's understanding of their purpose. I mean, that's all right on your case, isn't it?
Well, it might, and if they do, you have to explain why. Why do purposes which are not purposes of the appellant in entering into the loan relationship, they are purposes of other actors in relation to other aspects of wider arrangements of which the loan relationship forms part, informative? That's the very criticism that Lady Justice Falk makes of the Upper Tribunal in BlackRock, not indicating. And it's quite clear when you look at the reasoning of the FTT and the Upper Tribunal below, that they thought it was permissible for them to just look at the purposes of JGI and other actors in relation to the wider arrangements, and we say that was an error. So essentially, the Upper Tribunal, we say, falls into precisely the same error as the FTT in focusing on the wrong purposes, and then that error feeds into the remainder of its decision. So picking it up at 71 through to 79, here the Upper Tribunal endorses essentially the two guiding principles in the FTT's decision, and it does agree that the reference to related transactions was an error of law, and it also floats the idea that the reliance on Lord Pearce's speech in Brebner may have been erroneous, but essentially it dismisses those errors as immaterial on the basis that what the statutory test permits is an assessment of all the facts and circumstances, in particular of the wider arrangements, and not just the purposes of the borrower company in entering into the loan relationship in question.
That's what they say at 78 and 79.
Correct, yeah. So for the reasons that I've already submitted, we say that that was wrong. Similarly, in paragraph 87, the Upper Tribunal says the FTT rightly identified the Deloitte scheme as the context in which it made its findings, and it was correct to do so. As discussed above, the inquiry under 441 and 442 permitted consideration of all the circumstances and asked why the appellant, as opposed to another entity, was chosen to be a party to the loan relationship. Understanding the Deloitte scheme with its regard to the tax position in other jurisdictions was a key part of understanding the genesis of the appellant's role. And again, we say that is not the correct approach. The purposes, the genesis of the appellant's role, the purposes for which the appellant exists or is chosen as the acquiring entity as opposed to any other group entity, should not be conflated with the purposes for which the appellant was a party to the loan relationship. In paragraphs 90 and 91, the Upper Tribunal dismisses the appellant's criticism that the FTT failed to identify that the startlingly obvious purpose for borrowing the money was to fund the acquisition of LTT, and instead focused on the corporate group's choice to use a UK holding company to make the acquisition, rather than focusing on the appellant's purposes in borrowing. And we say that that criticism is not unlike the criticism in paragraph 153 of BlackRock, and in our submission, the appellant's complaint is equally valid. In paragraph 98, the Upper Tribunal here grapples with the point that, taken to its logical conclusion, the FTT's approach would mean that a legitimate debt versus equity choice would fall foul of the unallowable purpose rule, and concludes that it would all depend on whether obtaining a deduction for loan interest was a main purpose or not. And as I've said, in that scenario, a simple debt versus equity choice, we say arguably there's no tax purpose at all, whilst tax might be the reason, the motive for choosing debt over equity. The purpose is to fund the commercial acquisition, and we say that is consistent with paragraph 150 in BlackRock, where Lady Justice Falk makes the observation that it cannot have been Parliament's intention that the inevitable consequence of taking out a loan should engage the unallowable purpose rule, subject only to considerations as to whether or not that's a main purpose. She says something more is needed. However, we would say even if the choice of debt over equity, because it is more tax efficient, means that there is a tax purpose, it would, in our submission, be an unusual and rare case where borrowing used to fund a commercial acquisition for reasons of tax efficiency meant that obtaining a tax advantage was a main purpose for which the company was party to the loan relationship. And then at 99, the Upper Tribunal says, standing back, the outcome resulting from the FTT's approach is one which falls squarely within the scope of the provisions. The FTT found here that securing the tax advantage was a main purpose of the appellant being a party to the borrowing, rejecting the evidence that there was a commercial purpose to being a party. In other words, the acquisition of LTT was parked in the UK, not for commercial reasons, but in order to obtain loan relationship debits. Any disquiet at this result stems from an erroneous assumption that the reasons why a taxpayer is chosen to make the acquisition are ruled out of consideration, or that the use of the borrowing to buy a commercial asset is determinative without regard to the wider circumstances in which the borrowing occurs. And in our submission, standing back, there should be obvious disquiet in an outcome whereby interest on arm's length borrowing required and in fact used to fund a commercial acquisition is denied. And we say the reason why the Upper Tribunal gets comfortable with that outcome is because, like the FTT, it focused on the wrong purposes. And then I just want to pick up a couple of aspects of the Upper Tribunal's analysis on the finding that there was no genuine decision-making by the appellant's directors, and that's at 139 to 142. And I just ask you to read those paragraphs to yourselves, please.
Yes.
So the Upper Tribunal repositions the FTT's comments as simply seeking to convey the point that the appellant's decision to enter into the loan and acquire LTT was effectively a done deal. And we don't take issue with that per se, because what it demonstrates is that the opportunity to acquire LTT was a commercially attractive proposition. It doesn't mean that the appellant's board had abdicated decision-making responsibility. Indeed, that would run contrary to Mr. Olson's unchallenged evidence recorded in paragraph 140, that the appellant's board took its own independent action to satisfy itself that it was acquiring a good investment. And importantly, the Upper Tribunal accepts that the appellant's board was acting in accordance with its fiduciary duties, and that in resolving that the appellant would borrow and then acquire LTT, that it was making a valid decision. So as such, we say the relevant subjective intentions in ascertaining the purposes for which the appellant was a party to the loan relationship are those of the board of directors of the appellant. And finally, to the extent that the Upper Tribunal endorses the FTT's findings that the board memo, board pack and board meeting were designed to give the illusion of independence, of independent decision making and disguise the existence of a tax purpose, we say it was wrong to do so for the reasons already articulated and set out in paragraph 154 of the judgment in BlackRock. In other words, it was, we say, entirely proper in circumstances where the appellant was not itself going to benefit from the tax advantage to leave tax considerations out of account. So I was going to move on then to my second ground of appeals, if that's a convenient moment to break.
Yes, by all means. I know we've been bombarding you with questions, but how are we doing for time?
We're doing well. I'm a good 2/3 of the way through my notes.
All right, 2 o'clock.